Hi, everybody. My name is Graham Simmons, and as Allison said, I'm an attorney with Norris McLaughlin. My practice tends to fall in two primary buckets, being business and corporate, but I also do a significant amount of real estate work, which includes all manner of conveyancing, leasing, land development and zoning. But part of that also ventures into federal requirements that affect these sorts of things. And so I'm going to go ahead and share my screen. So today we're talking about a new requirement that is coming to us by virtue of the feds. Hold on a second. Let me see if I might just have to share my screen entirely, which is fine. I'll go ahead and just do that. Okay. So just to go ahead and so just to kind of level set. So we're going to go through and just talk about what the requirements are, some of the practicalities around them. There will be time for questions and answers at the end of the program. So as Allison said, if you're able to just keep yourself on mute while we get through the program, be more than happy to stick around for a little while and answer any questions you might have around these reporting requirements. And so, just to start with what is this? So the Department of Treasury has their Financial Crimes Enforcement Network. And so somewhat of a shameless self-plug, you might remember I did a similar seminar about, maybe about a year ago, relative to something called the Corporate Transparency Act, where they were imposing reporting requirements on different entities where you would have to report the beneficial owners of those entities. And the purpose of this is obviously to combat money laundering and terrorism and general ne'er-do-wells. Now, this is a bit more targeted in the sense that this is a final rule, meaning an actual regulation.
That you can put her into my voicemail.
Sorry, if somebody could mute themselves, please.
Okay, thanks.
So this is targeted over concerns about what the feds have viewed as an area of the real estate industry that is subject to folks who are trying to engage in money laundering and other illicit activities. This is a regulation that was issued by the Treasury Department, and so I may keep referring to that as the final rule throughout this program. But in essence, it requires certain people who are involved in real estate closings and settlements to report information to the Treasury Department about certain transfers of residential real estate that they view as high risk for illicit finance. And so generally speaking, the reporting person must report details about the parties to the transfer and the property itself. We are not under the time pressure that we were about a week or two ago. Originally, the final rule was scheduled to take effect on December 1st. However, as of September 30th, FinCEN has postponed the start date to March 1st, 2026. The stated reason behind that was that they want to give businesses time to, figure out their compliance efforts around the rule. And they're trying, at least in their words, not to be too much of a burden upon business. So with that said, what does this generally require? Well, it's a real estate report that has to be filed with FinCEN for certain transfers, as I said, of residential real estate that they view as high risk. And it must be filed on any reportable transfer, which is essentially defined as a non-finance transfer to a transferee entity or transferee trust of an ownership interest in residential real property. So that's a mouthful, obviously, and I'm going to take you through all of that to explain it in plain English as we go through this. But it, generally speaking, has to be filed within 30 to 60 days of closing. The rule itself says it's the later of the last day of the month, which follows the month when closing occurred, or 30 calendar days after the closing date. Okay, and that's okay. And then the form gets filed electronically with FinCEN. I included the link here. I will tell you just as a practical matter, it's useless because it's been that site is not active yet with FinCEN, but ultimately that's where the report will get filed by the reporting person as part of the transaction. So, why is this important? Okay. So negligent violations of the final rule can result in civil penalties of $13.94 per violation and an additional civil penalty of over $108,000 for a pattern of negligent violations. So what would be a negligent violation? Somebody who has a general awareness of this, but generally speaking, is not compliant or might not be complying in the right way. Willful violations of the rule can result in criminal penalties of up to 5 years imprisonment or up to $250,000 in criminal fines and an additional civil penalty. And you'll see that's not more than the greater of the amount involved in the transaction, up to about $278,937 or $69,000 and change. So those amounts can change over time, by the way. Like many things with the feds, they kind of index them to increase over time. But currently, that's what violations could potentially result in once the rule goes into effect on March 1st of next year. Now, I'm going to just inject a quick dose of reality into this, which is I fully expect, and there's already been instances of this, but I fully expect that industry groups are going to file lawsuits. I fully expect that Congress might try and pass legislation to either delay, to reduce the scope of this. You'll remember the Corporate Transparency Act. That was such a big deal last year in terms of people complying and filing their beneficial owner reports. And ultimately, despite courts saying it was either constitutional or not constitutional, injunctions being entered. Finally, the Department of Treasury entered a rule basically saying, unless you're a foreign entity, then you don't need to comply with it. Now, that's a regulatory interpretation. It doesn't mean the statute went away. But for this foreseeable future, Corporate Transparency Act went away, but you still have this real estate reporting requirement, which you're going to hear throughout this. If you remember anything about the Corporate Transparency Act, there are similarities, but there are some significant differences between the two as well. So, and I think this one has the ability to impact things, certainly from a record-keeping standpoint, in a bit more of a realistic way. But we're going to take you through the practicalities of all that throughout the program. So, as I said, a reportable transfer is a non-finance transfer to a transferee entity or transferee trust of an ownership interest in residential real property. So, basically, a non-finance transfer is anything that doesn't involve the extension of credit to the buyers and that is both secured by the transferred property and extended by a financial institution, which is subject to anti-money laundering requirements and suspicious activity reports. So, in other words, if you have a transaction that's an all-cash deal, okay, it doesn't involve a bank that's taking a mortgage. And when I say bank, I don't mean a hard money lender. I mean your traditional, regional, national, and even local banks that are subject to those requirements. Sorry, let me go back. So, transfers of residential real property, again, anything involving a deed or any other indication of ownership. Keep in mind, this is less of an issue in our market area. But co-ops, they're very big in New York City. And those, you don't get a deed when you buy a co-op. It's usually evidenced through stock, shares, or other contractual agreements. So anything that gives an indication or a legal document that indicates ownership, that will count for a transfer. It's obviously worded very broadly to encompass all manners of transactions. I think the other thing that's noteworthy here is it also applies to transfers of ownership for which there is no consideration, such as a gift. Now, one might question the viability of that because practically speaking, when property transfers and it's done as a gift, how often is a real estate professional, quote unquote, like a title company, a realtor, or even an attorney in some cases involved in those transfers? It's not, it doesn't happen all the time. So one could, from a policy standpoint, question the efficacy of that. But I also say, just to reinforce the notion that this has broad application and it's meant to be more encompassing than not in terms of what an actual transfer of residential property is. Now, when I say, what's residential property, it's anything you would traditionally consider to be that, okay? Single family houses, townhouses, condos. It even applies to situations where there may be a commercial element, such as a condo that has a commercial unit as well as residential units. It most certainly applies to, I'll call them apartment buildings, condos, co-ops with several units in them. And so it could also apply to land on which the transferee intends to build a structure designed principally for occupancy by 1 to 4 families. So if you think about lot purchases, that could potentially fall within the ambit of the rule. I can't say that it's a one size fits all. It's a fact, it's a facts and circumstances analysis. But if there's an indication, that you have a lot, and I'll just give a practical example. You have a transfer of a lot that's located in an R2 or an R3 zoning district. Well, I would tell you that if you want to take the more conservative approach, I would treat it as residential property in that case. Now, that doesn't necessarily mean just because something is residential that it's going to be a reportable transfer. It's just one part of the analysis, but it is a part of the analysis that is more encompassing than not in terms of what is included in the definition of residential property. So now, I will say, are all transfers reportable? No, of course not. With every rule comes exceptions. And common exceptions in this case include transfers involving easements. That one was particularly interesting to me, just because, consideration is and often paid in connection with easement interests. But for whatever reason, the feds felt like that was not an area that they felt that they needed to focus on from a reporting standpoint. Transfers resulting from a death, by will, trust, whatever it might be, even if I die without a will and under the Intestate Act in Pennsylvania, property is going to transfer to either my spouse or to my parents, that would not be a reportable transfer. Transfers into bankruptcy estates, that's otherwise supervised by a court. Interestingly, I said earlier that transfers that are gifts are not typically, are included as a transfer for those purposes, but there is a specific exemption by transfers to a trust for no consideration, where the individual, their spouse or both, are the settlers or the grantors of that trust. Transfers to qualified intermediaries for 1031 exchanges are also exempt from the reporting requirements. This list, I should note, is not necessarily comprehensive. There could be other scenarios which are ultimately exempt. And like all things regulatory, the feds always reserve the right to make changes down the road. So there could be additional exemptions that come down the pike from a regulatory standpoint. Congress could certainly try to, pass legislation where they would additionally exempt other types of transfers. But for now, these are the primary ones that are excluded as exempt under the final rule as it's currently written. So the question then becomes, okay, so we've got a transfer because there's a deed. It's residential real estate, okay? There's no bank involved. It's an all cash deal. So, okay, so far this is a pretty easy analysis, right? So now, to be reportable, the transferee has to be what they call a transferee entity or transferee trust, okay? And so the definition of that is if it's a transferee entity, that's anybody other than a transferee trust, okay, which we'll talk about the definition of that, or an individual, okay? So transfers from Allison and I to each other, okay? It might be an all cash deal, might be no bank involved, might be residential real estate, but we're individuals. So that is not going to be a reportable transfer, okay? But if you have any kind of an entity, a corporation, partnership, limited partnership, an estate, association, limited liability company, those all count as transferee entities. So I would argue even a general partnership, okay, would count as a transferee entity. because it is actually a separate entity that has its own EIN. There might be individual liability for the general partners in a general partnership. However, it's got its own EIN, and I think it very well falls within the definition of a transferee entity. Now, I will say there are certain entities that are exempt. And again, for those of you who remember Corporate Transparency Act, it's a very similar list of entities that are exempt from these requirements. So if you have a bank, a credit union, a publicly traded company, public utilities, securities brokers, dealers, I think the theme that you're probably recognizing here is these are very heavily regulated entities where there are strict reporting requirements and understanding in terms of who the owners and who controls these types of entities. So, I'll go back to the example I had earlier, which is, okay, it's an all cash deal and it involves residential property. There's no bank involved, right? But the transferee is a registered broker dealer. Well, that takes it out of the reportable transaction because that is not a transferee entity. Now, transferee trust, I'll talk about that for a moment. So a transferee trust is basically any legal arrangement which is created when a grantor or a settlor, in plain English, that's somebody who sets up the trust, places assets under the control of a trustee for the benefit of one or more beneficiaries or for a specified purpose, okay? And I should note that a trust can be a transferee trust regardless of whether the residential real property is titled in the name of the trust itself or in the name of the trustee, which is not an uncommon thing to happen. Like the transferee entities, there are exceptions to that. Again, securities reporting issuers, statutory trusts like Delaware trusts. If the trustee is a security reporting issuer, these are not common, obviously, and certainly in terms of residential real estate, unless you have something that's somehow bundling up a lot of properties and trying to sell securities on some sort of secondary market. It's just not something you're going to run into much. But again, as I said earlier, every rule has its exceptions, and these are the exceptions to what a transferee trust might be for purposes of whether or not you have a reportable transaction. Now, you might have situations where there are multiple transferees. It only takes one who constitutes a transferee trust or a transferee entity to be a reportable transaction. However, if that's the case, you don't have to report information on every single transferee, but you will have to report information on the ones that do count or qualify as a transferee entity or transferee trust in those cases. So who's required to file the real estate report? So the reporting person, is somebody who, and only one person can be the reporting person, okay, for these purposes. And I'll sort of walk you through that a little bit, okay? But there's two primary ways you become a reporting person, okay? There's a reporting cascade described in the final rule, and I will take you through that in another slide. The other way is by way of a written designation agreement by real estate professionals described in the final rules cascade reporting order who are involved in the transfer. So, and I'll note the reporting cascade is going to look somewhat similar to those of you who might have your own title companies, as it's very similar to the reporting cascade for who's required to issue the 1099-S in these transactions. So now it lists 7 different functions that a real estate professional may perform in connection with a reportable transaction. And as I said, it's similar to the Form 1099-S reporting cascade. So if there is not a designation agreement, and I'll talk more about that momentarily, then the reporting cascade is going to be used to determine the reporting person for the transfer. So at the top of this list, and again, it goes in descending order, okay? So think of this in order of priority, okay? So the number one or first person that will be responsible as the reporting person is the closing or settlement agent on the closing or settlement statement. Now, I think there's a recognition on the Fed's part that in many cases, that's going to be the same person, quite honestly. And so, it's a rare situation where you would have a separate closing or settlement agent, separate from, a title company or something like that. But that's the first person who would be responsible for making this report to FinCEN once this goes into effect. Following down the line, if there is not a closing or settlement agent listed on the closing or settlement statement, whoever prepared that statement is next in line. And then whoever would file the deed or other transfer instrument with the recording office. In many cases, that could be an attorney. And actually, as much as I'll tell you quickly, the American Bar Association and some of our other, professional associations objected to this on the basis that it might violate the attorney-client privilege. The Treasury Department did not see it that way, and actually noted in the proposed final rule that they believe to the extent it would even constitute a violation of attorney-client privilege, it falls within certain what I'll call common law exceptions to the privilege. So I'm not sure if that's going to be the end of the story. As I said, I mean, I do foresee, and it could be the American Bar Association or other professional associations filing a lawsuit over this, but for now, attorneys are most certainly could be within this reporting cascade. Next down the line is anybody that underwrites an owner's title insurance policy for the transferee. My guess is that, to the extent that your Commonwealth, Fidelities, and the actual title insurance companies would fall within the ambit of this, they are absolutely going to want designation agreements, which require their agents to be responsible for this report. I don't see them undertaking responsibility for this. And then following on the cascade, anybody that disperses in any form, including from an escrow account, trust account, or lawyer's trust account, the greatest amount of funds in connection with the transfer. Anybody that provides an evaluation on the status of the title, or anybody that prepares the deed or other legal instrument that transfers ownership. Now, it might be rare, but there could be circumstances where you have a transfer where none of these folks are involved. If that is the case, then it's not a reportable transaction in that case, because who's going to report it? Again, that's going to be, I think, the exception to the rule. And I think that's one of the reasons why the Treasury Department specifically wanted attorneys in the reporting cascade, because more likely than not, if you don't have, title insurance involved, there's no real estate agent or a title company, anybody like that involved in the transaction, more likely than not, you're going to have an attorney who either prepared or is going to file the deed. And so I think FinCEN is viewing that as their catch-all way of making sure that something that might otherwise escape scrutiny gets reported. So we'll talk about designation agreements. So as I said, anybody who's part of the reporting cascade, they can choose to enter into a written agreement that designates another person who also performs a function within the reporting cascade as a reporting person. So, I think, I would just kind of stress again, that has to designate somebody who otherwise would be a reporting person. You can't just designate your nephew to be the reporting person. It has to be somebody who falls within that cascade. And as I said, I kind of alluded to this earlier. This is why I foresee, the title insurance companies are very likely going to have, probably require these with their agents, because I don't think they're going to want responsibility for making these reports to FinCEN. And as I said, the person who would otherwise be a reporting person has to be a party to the agreement. Okay. However, if you have a situation where you have maybe 3 or 4 different reporting persons involved in a transaction that fall within the cascade, not all of them have to be parties to the agreement. It's just between the two that, ultimately decide, okay, I would normally be the reporting person, but I don't want to be, you're going to be, and that person agrees to be the reporting person. So there's no required format, at least under the regulation, in terms of what the designation agreement has to look like. But it has to at least be in writing, has to identify the date of the agreement, the name and address of the transferor, the name and address of the transferee entity, or trust for that matter, the property involved in the transfer, and then the name and address of the designated reporting person, and then the name and address of all parties to the designation agreement. So I can certainly foresee, and I don't have any insight on this, but I could certainly foresee some of the trade associations, title association, or even Pennsylvania Realtors Association, probably coming out with form documents around designation agreements. It's important to note that, it's not a one and done situation. Okay. A separate designation agreement is required for each reportable transfer. So it doesn't, while the final rule doesn't prohibit you from having an understanding broadly with others in writing or otherwise as to how you generally intend to comply with the rule, there has to be a separate designation agreement for each reportable transfer. Okay. I'll also note there's a record keeping aspect to this as well. It's got to be retained for 5 years. And it does not, by the way, have to be filed with the real estate report with FinCEN, but you have to keep it on file for a period of 5 years. So let's talk about the real estate report itself. Okay. So, okay, we've gone through sort of the mechanics of, okay, is this a reportable transaction? Well, does it involve residential real property? Yes. Is it really a transfer involving a deed or some other legal document indicating ownership? Yes. Is it non-finance, meaning there's no bank involved? Yes. Okay. And is the transferee a transferee entity or a transferee trust? Yes. Looks like it is. Okay. So now, we've also talked about, well, who's going to file it? Okay. We figure out either through the reporting cascade or we have a designation agreement. We're gonna, this person is going to file the real estate report. So what do they submit? So, they've got to submit information necessary to identify themselves, the residential real property, which is the subject of the transfer, the transferor, the transferee, entity or trust, any individuals representing the transferee in the transfer, and beneficial owners of the transferee entity or transferee trust. Okay. So again, some of you who remember Corporate Transparency Act, you're going to remember beneficial owners. That sounds familiar, and it is going to be familiar to you if you remember that. And I'll talk about that momentarily. Additionally, the real estate report has to report the total consideration paid for the property, as well as certain information about any payments made by the transferee, again, entity or trust, which includes the method of payment, the name of an account number with the financial institution, okay, originating the payment, and the name of the payor. So I'm going to come back to that because I think, right now in your minds, you're thinking, okay, how the heck am I going to document all this? What do I have to keep in my file? What am I going to submit to FinCEN? Am I basically becoming a detective on behalf of the government here? Like, what do I need to review to know all this? So, and we're going to walk through that. Okay. So let's just start with, okay, who are the beneficial owners? Okay. And again, it's relatively the same as what was the subject of the Corporate Transparency Act. Okay. Any individual on the date of closing, either directly or indirectly, that exercises substantial control over the transferee entity or owns or controls at least 25% of the transferee entity's ownership interests. So I don't want to spend an inordinate amount of time talking about, the first test, but it is either or, okay? Either you have substantial control or you own or control at least 25% of the ownership interest. So 25% owner, okay, that's an easy thing, okay? That's fairly black and white, okay? Substantial control is a much more facts and circumstances determination. And so what do I mean by that? Well, let's take a couple of different examples. So in one case, you might have a transferee entity that is a corporation, okay? And in that corporation, I have two owners, one of whom owns 80%, the other owns 20%. But that corporation also has a board of directors, okay? And that board of directors is responsible for the management of that corporation. And we'll say that board of directors consists of three people, okay? One of whom is the 80% owner, one of whom is the 20% owner, and then the third one, we'll call them an independent director, okay? So, and I'll take it a little bit of a step further, okay? Well, I'll tell you what. So let's just start with the construct that I laid out, okay? So 80% owner clearly owns at least 25% of the transferee entity, okay? So there, okay, so that's a beneficial owner, no problem, okay? The 20% owner does not own or control at least 25% of the ownership interest, so they may not be a beneficial owner. Okay, sorry if you could mute yourself, by the way, there. Thank you. But those are the owners, but as I said, the board of directors is responsible for the management and control of the business of the corporation. And you've got three directors here. Okay. Well, let's start with the 80% owner. Okay. We already know he's a beneficial owner because he's an 80% owner. He might be one of three on the board of directors, but we don't really need to go through that brain damage because he already owns 80%. Okay. What about the 20% owner who's a director? Are they really exercising substantial control over the transferee entity? I can make an argument that they're not. They're a minority owner and they're one director out of three. So they alone can't make decisions if it's majority rules on the board of directors. Okay. And then lastly, there's the independent director who doesn't have any ownership in the corporation. Well, that independent director, I would argue, is not a beneficial owner. They don't have ownership and they alone can't exercise substantial control because they're one vote out of three and it's a majority rules on that board of directors. Okay. So what would maybe change my analysis about the 20% owner through their role on the board of directors? Well, what if they had certain veto rights where they would either have to approve or they could veto certain actions on behalf of the board of directors, even if the 80% owner and the independent director agreed? That could potentially change the analysis. So I'll give you another example, okay? We have an LLC, okay? And we'll say it's a member-managed LLC, so there's no manager involved, okay? And it's two owners, 50% each, okay? So, again, this becomes an easier exercise because, well, wait a minute, they both own and control at least 25% of the ownership interest. So that's the end of the analysis in that case, okay? We don't need to worry about anything else. You could get yourself tripped up over whether or not either has substantial control because it's a 50-50 proposition. And if the governing documents provide that, majority rules, well, you could argue that neither has substantial control, but it doesn't matter because they both are 50% owners. So again, I don't want to spend a ton of time on that, but I'm just using that to illustrate, okay, it's kind of a facts and circumstances analysis typically. But the good news is, and I can almost see some of you sweating about, wait a minute, am I going to have to start reviewing corporate documents in depth and, understanding business law in terms of, what's the ownership and control structure for corporations versus LLCs versus limited partnerships versus, statutory trusts? The good news is no, and I'm going to explain why in a few slides. So now let's talk about a transferee trust for a moment. All right, the beneficial owners of a transferee trust is anybody who at the time of transfer of the property is a trustee, otherwise has this authority to dispose of the trust assets. The best example I can give there is a trust protector, which typically has the authority to act when there are no more designated trustees of the trust. A beneficiary of the trust, who is the sole permissible recipient of the income and principal from the trust, or has the right to demand a distribution or withdraw substantially all the assets of the trust. It could be, again, a grantor or settler. Again, that's the person that sets up the trust, who has the right to revoke the transferee trust or otherwise withdraw the assets of the transferee trust, which that's basically any revocable trust, by the way. Okay. And then lastly, the beneficial owner of a legal entity or trust that holds one of the positions described in any of those four categories. I'm not going to spend a whole bunch of time on this, just because, again, we could get lost in different examples and variations on that. Again, it's just reinforcing the point that it's a facts and circumstances situation. But again, like transferee entities, you're not going to have to become experts on trust documents and trust law in Pennsylvania. So let's talk for a minute about how should this information be collected, okay? So obviously they need identifying information for any beneficial owner of the transferee entity or transferee trust, which includes name, date of birth, residential address, citizenship, and taxpayer identification number. The reporting person also has to report the total consideration paid for the property, along with the information I described about the payments. And that includes, where those payments originated from and the account information. So here's my good news for all of you, okay? You may rely on information provided by other persons for purposes of reporting information, okay? Or determining whether or not you need to comply with this rule, but only if you do not have knowledge of facts that would reasonably call into question the reliability of the information, okay? And so generally speaking, the feds are calling this a reasonable reliance standard, okay? However, I have to note that it's a bit more limited when it comes to the reporting beneficial ownership information, okay? And why is that? Well, because it can only apply to information provided by the transferee or the transferee's representative, and only if the person providing the information certifies the accuracy of that information in writing to the best of their knowledge, okay? So, the good news is, and I guess the practical upshot, unless you are dealing with somebody that does not have an EIN or taxpayer identification number, you're not going to need to submit or request copies of driver's licenses and passports. Now, I appreciate, just as a practical matter, when you're sitting around a residential real estate closing, the title company or whoever is typically taking copies of, driver's licenses because that's needed for notary and other purposes. But you're not going to need to collect or retain that information for these purposes, okay? Obviously you need the EIN itself, account information, but again, they're not imposing what I'll call a diligence standard where you have to get copies of this and you can't rely on anything else. If somebody is telling you this is the EIN, how would they do that? Well, a W-9 is one example, right? You might have your own form around that as well. And I'll talk more about that in a moment. But if somebody is certifying the accuracy of the information to the best of their knowledge, then that meets the reasonable standard, okay? What's an example of a situation that might not meet that standard? Okay, well, let's say it's a transaction involving a corporation, okay? And, you're being told that, person A and person B are each 50% owners of the corporation. And, those are your beneficial owners for reporting purposes. But for whatever reason, at the closing table, the attorney's file spills out and you see stock certificates for 4 or 5 other people who, let's say they're all, in one form or another controlling. So, obviously now you have knowledge of facts that would call into the question the reliability of that information. That, that might be somewhat of a remote example, but I just use it to illustrate, look, if you can't turn a blind eye to something that comes to your attention, okay? If somebody is telling you the information and it's the transferee or let's say their attorney, then under the reasonable reliance standard, and if they're certifying the accuracy of it to the best of their information, then you can rely on it for these purposes. Okay, but again, you can't turn a blind eye to facts that come to your attention that would call into question the reliability of the information. And I'll note, the certification regarding beneficial owners, it can be collected using a form of your own choosing or design. Could be incorporated into other existing closing documents there's not really a mandated form or template from the Fed standpoint. Again, like the designation agreement, could I see industry associations developing templates around that? Yeah, absolutely. And I know some of the larger title organizations or title agencies have already done that. So, just to reiterate, the real estate report, it's got to be filed by the last day of the month following the month when closing occurred, or 30 calendar days after closing, whichever is later. So generally speaking, 30 to 60 days, from closing is when you're going to have to file the report. Okay. Now, what do you have to keep? Okay. So reporting persons, again, you have to retain copies of the certifications by the transferee or their representative as to the beneficial owners, and you have to keep that for 5 years from closing. Okay. Also, all parties to designation agreements, they have to retain those in their files for 5 years. Interestingly, though, a reporting person is not required to retain a copy of the real estate report itself. Now, practically speaking, that might be difficult. Not knowing what, FinCEN's electronic filing is going to look like because they haven't put it up yet. It might be difficult to do that anyway, just as a practical matter. But one of the, I'll say, policy reasons that was stated in some of the comments to the final rule in terms of why a reporting person would not be required to retain a copy of the real estate report. Well, again, that report contains account information. It contains EINs. It might contain somebody's social security number if they're the transferor. So I think there was a recognition, and I think there was some concern expressed by different industry associations that, look, while there's certain information that we're required to retain for certain periods, we don't want to become a database of people's personal information, especially sensitive information like that. And so, this is one area where I think FinCEN was at least heard the comments and the concerns. And so, you're not required to retain a copy of the actual report itself, or the reporting person is not. One other thing that I think was a concern. So wait, do I need my own anti-money laundering program or policy like the banks have? Thankfully, you do not. So I think just looking at the time here, we've got a little bit more than 10 minutes. And I think this is probably a good time to shift to questions and hopefully answers. But so certainly feel free if you have any questions, then feel free to unmute yourself and fire away.
Yeah, I have a question. Okay, this is Debbie Reinhardt.
Hi, Debbie.
How am I, as a licensed Pennsylvania realtor, going to have to file anything with this?
You may not as a realtor. And again, this has more application. If you're not performing any of those functions within the reporting cascade, then
Right.
it wouldn't apply to you in those cases. Again, this has more application where there's crossover between title companies and the agents, or if you are performing any of those functions within the reporting cascade. But if you're simply performing your functions as an agent and just showing
Right.
closing to get your commission and
Correct.
thank your client, then in my view, you don't fall within that reporting cascade.
Right. That's what I'm looking at. Okay, so let's
Now,
have.
let me just
Oh,
say though, you could potentially be a representative though, for purposes of somebody might ask you to certify if you represent the buyer and their transferee entity or trust, somebody might ask you to certify to the best of your knowledge, which again,
okay.
there's not necessarily a requirement that you do that. If it were me, I would actually prefer my client to do that for themselves.
Mm-hmm.
But outside of that, if you're performing the traditional agent roles, I don't see you falling within the reporting cascade.
All right. See, because a lot of my clients, they do pay cash for their properties. See, what they've done is they've taken a bridge loan against their current home
Mhm.
to purchase their new home. So it looks like a cash transaction at settlement,
Yeah,
actually,
well,
because of bank, but there's, quote unquote, a lien against their current residency, then that has to be paid off.
yeah, well, and again, it's the real estate that's being transferred in question, right? So,
Right.
and I would venture probably in the majority of those circumstances, your buyer is an individual. It's not going to be a transferee entity or a transferee trust, so it wouldn't be a reportable transaction in those cases. So,
Okay. Well,
you know,
let's talk. Oh, okay. I'm sorry. I was going to say, so let's talk about trust. So
mhm,
somebody has their property currently in ownership. Okay. A fee simple, tenants in common, tenants in the entirety, whatever type of
mhm,
thing. And they
yep,
want to move it into a trust.
that would be an exempt transfer.
That would be exempt. It wouldn't
As,
be
as
part of it
long as
either.
it's I'll give you an example. My wife and I own our house, as tenants by the entirety, husband and wife. We want to put it into trust, where we are, one or both of us will be the trustees for the benefit of our kids. That's an
Right.
exempt transfer under the rules.
Okay. So that doesn't,
Yeah.
okay.
Now, again, there is one additional element to that. We're also doing it for no consideration, right?
Right. Zero. Yeah.
Yeah.
No, right. There is no exchange of funds at all.
Right.
Okay. Yeah. I mean, I thought maybe we as agents were going to have to report something here.
Well, I think the awareness for you as agents is, well, do I want, if somebody asks me to perform one of these functions within the reporting cascade, I may or may not want to do that
Correct.
personally. But on the other hand, my broker might not want me doing that either, necessarily.
Correct. Yeah.
I mean, I appreciate everybody's an independent contractor as the agent, but you know,
No, some of these people have ownerships in title companies and everything. So,
yeah, I was going to say there's a lot of cross-pollination in terms of the roles with
mhm.
real estate transactions. So
Okay, thank you.
sure. Any other?
Graham, are you still there? I have a bad feeling we just lost Graham. Okay. Oh, he's back. Okay. Thought I lost you.
Yep, I'm here. All right, all right. I don't. Oh, yeah. I just saw some. Can you hear me? Okay, right now, Allison?
Yes, you're fine.
Okay, all right. Hopefully, I think it sounded like I fully answered the last question that was asked.
Yes. Yep.
Okay, so I was just saying, going once, going twice. Any more questions? Okay,
All right.
everybody's ready to get back to work. It sounds like.
Graham, thank you very much for doing this for us. We will probably post this in the Connect next week if you need to share it with somebody or need to listen to it again after your brain settles down a little bit. And I will see you all soon. Have a great rest of your afternoon.
Okay, thanks, everybody.
Thanks.